So first of all, the head of legal and regulatory APAC and India INFOBIP, Sharifah Thaherah. Can we have a big round of applause for her to joining on the stage? Mr. G.K. Ganesan Kasinathan, Partner Chambers, MESSRS, G.K. Ganesan, International Commercial Arbitration, Arbitrators, Advocates and Solicitors. Can we have a big round of applause for him? We have Rishi Ganiswaran, Head of Legal Technology and Chief Privacy Officer, YINSON Group of Companies. Can we have a big round of applause? So I will request all the speakers to take this forward. Thank you.
Okay, so today, all three of us, I don't think so we should be going into introduction because I think it's already there, and interest of time, and it's also lunch and everything coming up. So the topic today, as we know, it's international contracts and cross-border transaction. So when we talk about international contracts and cross-border transaction, we always focus towards, three things in a way or another. The challenges that we face during the pre-stage, and the challenges that we face after that. And when we do international transaction, we always have to think about the countries that we are supporting and where and how the cross-border transaction is. So looking at that and at which stage, so we have here, so thanks to GK, he's the one that have all of the presentations that is available that we can actually share with you after the session. So we are focusing into four stages actually: negotiation, contract formation, post-breach resolutions, and also enforcement. So I now give it to GK. So when you go into negotiation stage, what do we need to focus, and what are the challenges that all of us should be aware of?
Language. When you speak to an Englishman and he tells you your idea is remarkable, he's telling you you are stupid. If you go and talk to a Japanese businessman, there'll be 5 fellas there, one guy will have to make a decision, and he will never make a decision. If you're going to an American situation, they're all speed. They will tell you what they want. They don't give a damn about what you want. They will tell you. When you are with a group of Indians, they will not say no to you. They'll go round and round, because they don't want to be rude. It's worse with the Chinese. They will never tell you no. So language is important, because you are moving billions of dollars of merchandise across the sea, or IP contract, some code. You want to be able to secure and minimize any risk your client will face and make the other side happy. So by language, I don't mean, hello, how do you do, please, excuse me, none of that. There is a particular way of speaking English in England. If you go to the south of Watford Gap, there's a particular way of speaking English. If you go to America and you speak to a guy in Colombia, or you speak to a guy in, say, New York, it'll be different from a guy you are speaking to in Illinois or Philadelphia. They all have different media, and you've got to be sensitive about it. You've got to actually go down, get hold of. There is a book called there's a guy who wrote a book called Collision of Civilizations. Go and look for this book. A German will ask you, what happens if you don't pay the money? We will stop the supply, okay? Then 10 minutes later, he will tell you, suppose your money doesn't come into the account. We might not be able to proceed with the contract. 45 minutes later, he will tell you, you know the money that you're paying, what particular manner of transactions are you? Are we using codes, this particular keys? He's basically telling you again and again, no pay, no work. But they like to be very specific, and they'll repeat themselves many, many times. I've worked with Germans. They are very particular. They will repeat it 10 times, 20 times, just to make sure you get the idea. And then if you break once the word, they will no longer deal with you. So language is important. Thank you.
I think I agree with what GK is pointing out, that language is definitely important. But I think the other things that we have to also understand is about culture. And when we think about okay, we are all lawyers, and when you kind of deal into contracts, we forgot that the other side, when we deal with them, there is that side of the culture that we have to understand. Because what we do here, like for instance, I'm from Malaysia, I understand how the Malaysian works, but when you deal with the Indians, they have the Indian works. And how we do in Qatar, for instance, they have it as well, or even in the UK. So we have to respect that and breach that. So going into that, Rishi, what other formalities are required when doing the negotiation stage?
I think one of the formalities that I will personally look at is basically, as you said, which region are they from? I mean, based on which region are they from? Some cultures are more particular about the, how to say, their clauses that affect their particular country. For example, any anti-bribery clause, they'll get offended if you insert something like an ethics provision, which might seem common in like say the European culture and all that, and some will be a bit more amenable if you include like what's on the slide. It's not IP related provision. So intellectual property provisions doesn't mean a thing if you cannot enforce it in that particular country. So there's also region specific. For example, it is enshrined in Singapore as an IP hub. Okay, enforcing IP is one of our key elements that we are proud of. I mean, we have a Supreme Court dedicated to intellectual property, not so much in a third world country. So again, when we are negotiating this key aspects, we need to identify what kind of contract it is. What kind, is it a construction contract? Is it more of a data sharing agreement cross-border? And based on this, what are the key elements that is more favoring towards this contract? So I will look at those even before starting the whole kickoff process. What are, because we can't win the whole war, we just have to pick the key battles, the key clauses, and go for the kill. So it depends on what kind of contract it is, and based on that, what are the clauses we're looking for, and also what are the jurisdictions that govern this. So I will go for that, yeah.
Riding on the jurisdiction, I believe that governing law is also one of the most important elements into any contract. So, GK, in your experience, what do you think?
If you are entering into a contract, IP contract in Delaware, United States, and you're an Indian company, the first question you ask yourself is, something goes wrong, which court will make a decision? So there are two clauses. One is known as the jurisdiction clause, the other is known as the governing clause. So governing clause can mean three different things: substantive law, procedural law, and the law of the country that's going to hear your dispute. If you don't put that clause in your agreement, the country will decide for you. So if you're in the UK, then the UK law is, if you don't put a clause there concerning which is the governing law, the presumption is UK law is there. So if you're from most of us, I had this problem when I was working in Germany in one particular case. We all assume that all courts all over the world function under common law principles. In Europe, they don't. They function under the civil law principle. The judge will take on the role of an interrogator. So when you're drafting a clause, you really have to think about, if something goes wrong with this contract, where is it going to go wrong? Which court is going to make a decision? And does our contract minimize the risk of, getting screwed in France, for example? You really have to think about it. They will always come to you because you're the lawyer, right? If something goes wrong, it's your fault. If something goes right, it's a CEO's work, you know, it's nothing to do with you. Really. So whenever something goes wrong with the litigation, it's always the counsel, senior counsel who screwed it. But if you're terribly successful, he will tell you all the evidence I gave you, the clauses I helped you draft. So always think about it. You are going to get screwed anyway. Might as well be enjoying it while you're doing it. So be careful about jurisdiction, governing law. Which procedure are you going to use? Certain IP, some kind of evidence in Singapore. In Malaysia, has to be given in the form of an affidavit. In India, no, it's something different. You've got to be conscious of all of that, okay? So always, don't be stingy. Go and get the best lawyer in that country in IP and ask him pointed questions. Spend $10,000 US. Ask him, if this goes wrong, what's going to happen? If that goes wrong, what's going to happen? Don't be stingy and try and save US $500 and then end up paying $500 million in damages.
But I guess one thing, JK, there's when we go into negotiation, because I think half of us are mostly in-house, and when we go into contracts with the other side, all of us would have our own bargaining that we have to kind of, we want to protect our client, our company's interest. The other side will also want to protect the company's interest. So how do we kind of meet in the middle? So this is where at times the governing law, it will have to be based on how we have to negotiate as well with the parties. And I think the rule, I'm not too sure whether all of you will agree, the meet in the middle tends to happen. It's a win-win situation, or could be a lose-lose situation, but that losing is actually an anticipated risk, because when we go into that. So when writing on that, Rishi, do you think that on what I pointed it out would actually also goes into the reduce of the legal costs when you want to determine the governing law, or even from a governing law, it goes directly to dispute resolution, and dispute resolution goes into straight away to the arbitration, or where do you want to go, courts or arbitration? So what's your point there?
You see, that is, it depends, as you said, legal costs. Where do we want the least number of time and effort and money in resolving the issue? I mean, we have mediation, we have arbitration, we have litigation, we have expert legal opinions, so which is the driving force behind it. And usually if this contract is something that, like for example, data sharing, what is the most important element of it to prevent data from being disseminated further? So injunctive relief is probably one of the key elements. So that is something that should be enshrined in, if we are sharing any dispute resolution clauses, that should be then one of the things that should be in the back of the mind of the lawyer. It cannot be just arbitration by default. I mean, it has to be pursuant to what are the key risks identified and what is the harm that will be breached if we are undergoing some dispute. Let's say construction, okay, fair enough, it's a multi-million-dollar dispute, and arbitration can. But if you're talking about events that could probably will be seeking injunctive relief, then we have to think more than that. I mean, how long does it take for us to apply? And maybe Singapore is very quick. And also in the country as well. In some countries, there'll be a backlog. Even filing for injunctive relief will probably take forever. So it has to be suited from the legal counsel point of view. You have to educate the other counsel, if they're not aware, on that this particular jurisdiction, this particular court, what is the governing law, and why are you proposing this? Because it's beneficial for both sides to expedite matters, and it's useful for that particular court because both sides want to fix things quickly. So I think that's what I will propose, yeah.
Yeah, so now because we do have a few other things that we have to kind of, the negotiation state, I would say that what I can summarize from all of what I can say here is that we have to kind of do our a bit of a due diligence, understanding the other side parties. Actually GK pointed out one thing, should be beware of honeymoon phase. So now we go on to formation contract. So GK, in your point, and I know when I was reading this slide, there was something that is very intrigued on how you apply this. So maybe you want to share with everyone.
Yeah, when you are negotiating a contract, everybody's having a glass of wine across the table. There's sake, and there's food. There's all sorts of entertainment. You should be sitting there forgetting all that and asking, if something goes wrong, how the heck do I protect my company? What do I do? Where do I run for help? It's a thing called escalation clause. Before you rush off into litigation or arbitration, there will be an escalation clause, and there's a stupid way of writing an escalation clause and a clever way of writing an escalation clause. The simpler it is, the better it is. English words should be short and few. A sentence shouldn't contain more than 7 words. We teach that to our lawyers. If you have drafted a letter with more than 7 words per sentence, I would reject it. We hereby refer to your letter above. Why? Title is there, isn't it? Tell him what you want in 3 sentences. Your supply hasn't reached us. We will not be releasing payment. We await your response. Finish. Grandmother story, 3 paragraphs. Escalation clauses are in the event parties have a difficulty on the rights or duties or obligations in relation to intellectual property. The parties appoint 3 individuals who will be experts, and they will have to make a decision within 3 weeks. When we do sports arbitration, there will be an event going on in Olympics. Somebody will be tested negative or positive, and we'll have to make a decision like that. So you can't be messing about. So if you don't lay out the framework for resolution, when the dispute hits you, you're caught with your pants down, as it were. So you have to say, first is escalation. First, negotiate. Second, mediation through a party, a recognized mediator. Third, what is known as a mini arbitration. Lawyers will get together. Never allow lawyers into a negotiating table. Never. They will screw it up for you. I will always tell my clients, I'm here to screw you up. Do not take me, because the first thing I'll be asking is, what's the governing law? What's the law procedure? The other side lawyer will be talking rubbish, American fella. 45 minutes I'll be thinking, okay, if something goes wrong, can my clients pay $20 million to the lawyer just to arbitrate? I'm think. But escalation clauses, first negotiate, then mediate. Put in frameworks. Suppose you're going to mediate, who you're going to mediate with? Shipping contract. You got to bring some shipping expert, somebody respected in the, so do that. The next one is the honeymoon phase. Everybody will be lovey-dovey, while the contract is going on. When there's a screw up, then you can see all the fangs. The dripping blood all will come out. Anticipate that. Anticipate. That's your job. Your job is not to make money out of your client. Your job is to make your client's life easier, smoother, so that you basically work yourself out of a job, because you must make it easy for your client. Remember that. That's what you are there for.
Rishi, is there any that you wish to add?
I think further what I wish to add is, of course, certain things. For example, when do you want time was of the essence? I mean, depends on which side of the fence you're on. When we are the contractor, of course, we will try to say that, well, give us some time to extend, maybe don't terminate it, maybe you can substitute it with LDs and so on and so forth. But when you're the client, of course, time has to be of the essence, because I have a deal to meet and all that. So it depends on which side of the fence you're fighting on. But as I think what you all be familiar with, we will try to impose something of what I call a cascading effect. If certain clauses are imposed on us, we have to ensure that they are replicated downstream. So we can't be working on an upside down where we bear all the liability, and downhill they are caught free and easy. So it has to be a cascading obligation that is imposed. Whatever is imposed on us, we should try our best to cascade it down to those below us. Yeah.
Okay, when we do cross-border transaction, when we focus into the dispute, in your opinion, GK, what clause do you think that would attack in dispute countries? Whether it's interest clauses, illegality, or severance clauses, which do you think, in your opinion?
You are in the Middle East. You're performing a contract in the Middle East. There is a clause in your contract that says, if damages are not paid in such a way, then you are entitled to charge interest at, say, 2.5% per annum, compound interest or whatever. Can you enforce that in Qatar? Will the courts or the arbitration tribunal render it invalid? You formed the contract while you're having a party in France. You have to think about where the great deal of the risk is residing. So the contract formation is in France. One party is from the UK, another party is from India. The supplier is from Bahrain. So you realize the problem will be supply. If he's supplying from Bahrain, where will it go through? It goes through Qatar. The clearing of the port is there. They go through, clearing of the airport is there. They clear it there. 90% chance that the risk is going to be there. 90% chance arbitration or mediation is going to be there. Are there clauses in your agreement that are, how shall I put it, offensive to Qatari law? Think about it. You really have to think about it. What I want to deal now is to go straight away into, if you don't mind, we're running short of time. Everybody's hungry.
Excuse me, if you don't mind, I apologize. I have a call now, so I think I'll just
sorry,
take
I beg your pardon.
Yeah, sure.
All right. Could we go into contract formation and speak about it very, very quickly? Can I go to the slide before that, please? One slide before this. One slide before this. Yeah, this one. Before the 3 C's. Who's holding the mic? Yeah, go one step back. What we do is, while he's looking for it, we have a formula that we teach our lawyers the moment they walk into our firm in relation to international contract. 3 C's and an E, 1 T, 1 Q, 3 B's, 1 J. I'll tell you what the 3 C's are. 3 C's are care, clarity, concision, and enforceability. Okay, those are the 3. Next one. Then 3 P's. Identify, and verify. Somebody will come and say, I'm from the United States, from Chicago. We are selling this particular software, which is for, docking ships. It's used all over the place. First, identify the party. Second, identify the property. What is he selling you? Is he selling you the software, the rights to the software, or the license to the software? 3 different things. Third thing is price. How do you pay? Those are the 3 P's. Next, time. 2 T's. First, time of the performance and time of payment. So how do you perform? When do you perform? Next one, quality of performance. Your performance will be up to a particular spec that they will give you. If you are dealing with a technical subject, IP, there is a spec, specification. You have to see whether that's there. So next, B, 3Bs. 3Bs. There is a difference in common law between a warranty and a condition. And then there is, in Kawasaki Kaishin Kisha, in 1984, the House of Lords made a distinction between intermediate clauses. The Indian Supreme Court expanded on it. We Malaysian lawyers read Indian law, by the way. Yeah? 90% of our law is Indian law. So, what's the meaning of breach of warranty? Not so important term. You can still perform the contract. If there's a breach of a condition, fundamental breach, cannot perform anymore. So, how do you perform termination? How do you perform? What happens when there's termination? Is there a clause there that deals with, if the contract is to be terminated, a notice has to be given, a 30-day notice has to be given, time for remedial action has to be given. Put it all in the contract. Next one is jurisdiction. We've dealt with it. Mirror, mirror on the wall, who's the fairest of the mall? Where would you have your arbitration or your mediation or whatever else litigated? Next one is jurisdiction. I cannot overemphasize the importance of jurisdiction. We've spoken about it. I've spoken about interest clause, the next one. Then the next one is, engage legal expertise. And the last one is something that I notice a lot of my colleagues in different countries I work with say. It is called internalize your contract. The last next one, slide number 20. Internalize your contract. That means after you frame it, think about how the other side will think about it. And then how will you think about it? How will you perform it? So you're sitting in your desk in an aircon room at 3 o'clock in the morning, and your boss is calling you from, say, London, and asking you, what about this, what about that? He wants to sign the contract. He's not interested in all your objections. But you emphasize to him, send him an email. I am emphasizing this is important, all right? So those are the things. Next, we move to the last portion of it, the mediation point.
Maybe you want to cover as well?
Yeah, because you're rushing time.
It's okay, you can cover.
I can see that hungry faces, one Amoy sitting at the back. Right, now, you have to decide how you want to resolve your dispute. One is by mediation. You can work it into your agreement. The other is by litigation. Litigation is cheaper than arbitration. How much cheaper? About 20 times cheaper. I went into a dispute in Singapore about an European contract, European law, ICC rules. We paid $1.2 million to the arbitrators as fees before we started. The total contract was worth 300 US million. Counsel fees was on our side 5 million US. My client was just down. He won the case. He was down by 7.5 million US dollars. On the way back, he asked me, he is German, he asked me, GK, did we win? I think I've just got screwed. How do I explain to the board that we are down by 1.5 million? Don't go into arbitration. Don't. It's exceedingly expensive. I'm an arbitrator, I'm telling you. Your job is how they are getting together nice, the marriage is very nice now. Think about what's going to happen when the custody battle starts. Custody battle is for the assets. In Malaysia, we had one guy who said he entered into an arbitration. We had assets in France. They went and froze it. The government assets. The Attorney General had to intervene and they had to resolve it. So don't worry about how they're doing well. Don't bother. Think about what's going to happen when there's a screw up. And you'll be the most unpopular person in the room. Because you're constantly telling the board, this is going to go wrong, that's going to go wrong, the other is going to go wrong. They'll turn and tell you, can you shut up for a bit? But when the proverbial S hits the F, everybody comes and says, so what do you think we should do? Then you tell them all the emails. You see, I told you? So that's what you do. Thank you very much.
Okay, so I think we understand from where GK was pointing out about formation contracts, and earlier we were discussing about negotiation contracts and post-dispute resolution. Well, in summary, I think during the international contracts and when you do cross-border transaction, you have to really, really understand both parties, what they are doing, and at the same time, the understanding as well. When there are, like for instance, for me, I mostly do this with China contracts and all of that. The bilingual contracts are very important. Understanding the other side, the communications and style during the negotiation is very much important. So I think we wrapped up, and if there is any questions coming from the floor, oh yes, there are. So.
Thank you, panel members, for especially GK sir, for the speedy bullets touched. I just want to ask you, apart from language, what should be the best ingredient I should carry when it comes to negotiating a contract? Can we add one more C to your three C's, clear mind or clarity?
I would say be courteous but don't be humble. Huh? They look at you guys from a third world country, they think you're a piece of shit, you know. Never allow that. Stand your ground. You tell your client, if he pisses me off, you are not entering into the contract. There have been contracts I've just gotten up and walked away. Stand your ground, but always be respectful. You see, maybe the Japanese way of speaking is they cannot say no to you. They won't tell you no. They will tell you, perhaps, GK-san, Tashfa, maybe you reconsider it, you know. You reconsider, that means he wants you to say no. If you go to the Chinese, they won't say no to you. They won't say no to you. They will just, the head will go like that. Then you know you're screwed. If you watch people, elderly people across you see, law and practice is all about diplomacy. When I have someone who's above 50 years age and they take off the glasses like that, I know they're not interested. Because when you take off your glasses, your hearing drops by 20%. Did you know that? And when we were in law school in England, they used to teach us to watch the eyebrows, the throat. They swallow a lot. They are not comfortable. You know the English, they speak with the eyes and the eyebrows. They just move the eyebrows. The Indian flow is very easy. The hand will come out. You take an Indian flow, I hope I'm not offending anybody. The Indian flow, you tie his hands, he cannot talk. I am telling you, ask him, put your hand behind him back. Hold on, my lord. I am telling you, my lord. So the Indian flow, you tie his hands, he cannot talk. The Chinese person, there's a lot of movement of the head. In India, this means yes. This means I'm thinking about it. Don't think India, this means no. So you really have to understand the cultural norms. If you're in Japan, the meeting is at 10 o'clock, turn up at 9:55 at the door. Not at the receptionist, at the door. You wait. And then there are 35, can you imagine this? There are 35 levels of bowing, you know. Bloody hell. Sorry, you know. Went to Japan, they told me in Tamil, in Tamil, you know, 35 methods of bowing, you know. So I was thinking, what 35? Only know one. I go to temples 35, I do like that. So in India and in Asia, generally among us Asians, there is a general obsequiousness. You know what I mean by that? You're always like this. Don't take it too far. When you're in the West, sit up. No means no. A Westerner, you go to Germany, the fellow will tell you, can I get you a drink? Tada. None of that. At 8 o'clock, the negotiation will start. At 9:15, it will finish. He will get up and he will leave. He's not going to take you to the nightclub. Different in Japan. Different in Korea. In Japan, they'll exhaust you with the nightclubs. Okay, so diplomacy is everything. You really need to understand in which country you're working. I'm in Malaysia. When I talk to a Malay person, I'm very particular to keep my hands still when I'm talking to a Malay lady. They are Muslims. They get offended, and when they get offended, they won't tell you. They will smile. They are pissed, but they won't tell you. They're fuming, so you be very careful. And then when you're talking to Indian ladies, don't do this. Especially if the Indian lady is a CEO of a very powerful company. Indian women are exceedingly powerful. I'm married to one. So
You have not seen the Arab women yet.
They're like this, then you're dead. Be careful what you say. Observe. You see, you must go and buy all these books on body language. I notice among young lawyers these days, directly from Harvard, Oxford, we've got a couple in our firm, you know, first class honors. They think they're God's grace, you know, they're God's gift to the universe. I tell my lawyer, you shut the F up and be quiet. There'll be one old man in our firm without a tie. I'll say, let him talk. In 10 minutes, he'll tell me this is not going through. They're bluffing us. This is not going through. This IP contract, he says he is not the owner of the IP. He's bullshitting us. But everybody be polite. So by just observing people, you must be able, in Tamil, in Sanskrit, Samutrika Lakshana. Yeah? My parents taught me this. You observe people's faces. So I look at Sharifah. She's sitting like this. See, the hand is like this, isn't it? She's okay. If the hand is like that, she's not talking to you. She's talking to you, but she's not negotiating with you. You really got to see this in negotiations. That's all I will tell you.
Thank you. Thanks for that riveting discussion. As I take off my glasses, GK, this is directed to you. You seem to be discouraging arbitration in favor of litigation for various reasons that you've actually listed. But I don't know whether that advice would work in a jurisdiction such as where I come from, for instance, South Africa, or any third world country where you've got an issue with the court roll being clogged, lack of specialists sometimes, and a move to discourage litigation through courts and to take more arbitrations as a part of expeditious resolutions. Would you still maintain in such jurisdiction that we go the arbitration route?
Maybe I was not clear. I beg your pardon. I apologize to you. There is a view in certain third world countries that litigation is so poorly managed that if you go into court, it'll take you 5 years to get to the end of it. And the company, the CEO and the board, members of the board will be filing affidavits and sitting in conference calls with lawyers, which will take about 8 hours a day for 5 days. They want to do marketing. They want to sell products. They do not want to be sitting in a room like this dealing with arbitrators. But because of that, don't go into arbitration. There is a view in third world countries here. You know, don't go because the courts are not supporting arbitration. That's the first argument. The second thing is in France, in Belgium, in France, in London particularly shipping, London, New York, there is a highly advanced arbitral field out there. And if you go there, they are very fair, they are very precise, they will not bullshit you with 100,000 pounds. They will tell you 1 hour is equal to 750 pounds. Exactly 1 hour, he will charge you 750 pounds. He will not charge you 1,000 pounds. Whereas if you come to my country, I will just say 250,000 US dollars. Why? For what? No need. 250,000 or no dice. Because I know how much is involved. But you can't always speak like that. So arbitration is very expensive in the advanced, what we call them? The more advanced countries. Their law is very advanced, their lawyers are very mature. You go to Switzerland, you are dead. It's expensive. You go to Singapore, you will die. Hotel rates will kill you. You can arbitrate in Malaysia, for example, using a Singapore arbitrator because you think, I don't trust Malaysian arbitrators like GK. Okay, fine. You bring in your Singapore arbitrators, bring in your Indian arbitrators, bring in your Nigerian arbitrators, but arbitrate in Malaysia, 10 times cheaper. The law of governing law, England. Law of procedure, Singapore. You can arbitrate. You can arbitrate in Mauritius with English law, with French governing law, with Mauritian procedural law. Find the cheapest place. Always, all these, all these directors and all, they want to go on holiday, on board money. No. Arbitration is expensive. I do arbitration every single day. And I feel unhappy because my client is blowing $10 million on me US dollars when he could put it in infrastructure development, in marketing, in product improvement. So if you have a conscience, you have to tell your client, look. So by all means, encourage arbitration in fields, in countries where, and I'm not saying your particular country is any wrong. I think some of the African countries have really advanced arbitral and litigation system because they follow the Commonwealth model, yeah? The Westminster model. But be conscious of the costs. It's very expensive. We brought one fellow, for 1 hour he came to court and spoke about an expertise in a particular kind of gas pipes across the ship, 120,000 US, 1 hour. And the report he wrote was rubbish.
I guess if one thing I can add to what GK pointed out, in determining whether we want to go to arbitration or to the court, you got to identify as well with the contract price. You know, sometimes because what we are talking mostly is all on the high side. But when we say contracts, you can even have a $10 contract. And that $10 contract, for sure, we don't want to go to arbitration and all of that. It doesn't make sense. So you go to the courts. But there are situations where we would, like for instance in China, they prefer to kind of, go to the courts because they know that they have an upper hand. So it depends on your ability and when you negotiate, and always understand the other side, the country, where it is, you're negotiating it, and at the same time, where is the jurisdiction that you are agreeable with. And then, only then you decide whether you want to go to the arbitrator or arbitration or to the courts, and depending on the cost as well. Hope it helps.
Right. So Rishi, if you would like to, conclude this in one line.
At the end of the day, like what my fellow speaker said, seek the best possible legal advice you can. If you can't, then at least try to review all the clauses, which will then expose you to the least risk possible. Simple as that. Yeah.
All right, so can we have a big round of applause for all the key speakers who have joined us today? So kindly stay here for a group photograph, a quick group photograph.
I request Ms. Vitali to give certificate of participation to our panelists. Next we have Sharifah. Huge round of applause, guys. And last, Rishi. Huge round of applause, guys.